Greetings, ASA members. We have only one subject today, a very broad general subject, special education and service animals in our schools. This is an article that appeared in Principal Magazine November-December of 2019. Just recently, and in the holiday rush you may not have seen it, but it contains some excellent information. And it talks about common myths regarding service animals, and this is becoming quite an issue in our schools. First of all, this is the case based on the case of Fry versus Napoleon, a Supreme Court case in 2017. Okay, here's some common myths dealing with service animals, and I know that principals especially are dealing with this. Number one, people think any animal that provides help or comfort to a child with a disability is a service animal. No, false. ADA, Americans with Disabilities Act, has a specific definition of a service animal. I'm going to quote this here. Service animal means any dog, not a pony, any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. Specifically trained. Doesn't say a comfort or support dog. No, it doesn't say that. Number two, another myth. Whether or not a child with a disability has a right to a service animal directly relates to IDEA's concept of a free and appropriate education, FAPE. No. IDEA, Individuals with Disabilities Educational Act, relates only to FAPE. That's the special ed IDEA, that's all special education. That relates only to a free and appropriate education. That law is completely silent on service animals. For example, you might be providing a blind student a free and appropriate public education, and you might have an aide that carries the student from class to class. That might not be the best way to guarantee that kid access. So here's the issue with these service animals. There's really three laws that apply. There's IDEA, that's the special education law that deals with FAPE, free and appropriate public education. Then there's ADA, the Americans with Disabilities Act, and part of ADA is the third law, Section 504, which provides accommodations. Now, a service animal can be an accommodation. So you got three overlapping laws, and Fry v. Napoleon goes into great detail about those overlapping laws. Yes, it's complicated. We know special ed is a complicated issue. So, if a service animal is not required under an IEP, a school can deny a request for an animal. That's a common myth. No, because you could still have a kid with an IEP, and then the parents can ask for a 504 for a service animal. Go back to my blind student. He could have an IEP specifying how much education, how many hours of service, and so on. Then there could be a 504 saying needs a service animal. That would be a reasonable accommodation for a blind student, as opposed to, here's a cane, kid, okay? Number four, another myth. Other students' allergies or concerns, such as a fear of dogs or being allergic to dogs, would provide a basis to deny a request for a service dog. False. Unfortunately not. If other students in the room have allergies, guess what? You have to accommodate the students with allergies, and you have to accommodate the students with the service animals. You get to make everyone happy, because we're in the happiness business, right? We get to make everyone happy. In other words, you may have to assign students to different classrooms. And we know that's an easy thing to do. The other parents will be happy to switch teachers in the middle of the school year. and you, the principal, just get to massage the situation and make everyone happy. Number 5, if a service dog is a reasonable accommodation for a student with a disability, schools must include that provision in a student's IEP as a related service. Absolutely not. Don't put it in the IEP. Again, as I mentioned, IDEA is silent on the issue of service animals. But, and that's a big but, wait a minute, did I just say big but? Yeah, I did. However, I digress. Related services, remember, are necessary for the child to benefit from special education. However, that does not mean that anything and everything done for a child is a related service. And remember, a related service is provided by and paid for by the school. Don't put that in the IEP unless you want to pay for that service animal, and I don't think you do. So, don't list them in the IEP. Now, you can read this complete article in the Principal magazine. I've provided the link in this message. Here's a few final reminders of ASA's service to you that does not include any animals. A reminder that on Monday, January 13th, our next division meeting will occur in Mesa. You'll hear the regular update from the state board. You'll hear how to get paid, and not paid by you, paid foster grandparent volunteers in your school. You'll hear the latest update on comprehensive safety planning and more. Remember the Aspiring Principals Conference in Chandler on January 24th and the Aspiring Principals Conference in Southern Arizona at Rio Rico on February 27th. The second annual Carolyn Warner Women in Leadership Conference, March 31st, and the ASA ABEC Grand Canyon Maricopa Sheriff's Office School Safety Summit, May 7th and 8th. The new year is upon us. The new semester is upon us. Our old challenges remain. Preparing Arizona's youth for their futures in these uncertain times. And no service animals to guide us. But we do have our network of colleagues.